Hello everyone, welcome to this channel. We will be covering various aspects of insolvency and bankruptcy code here. So without wasting any moment, let's quickly dive into the basics. So friends, first of all, we try to understand what is insolvency, what is bankruptcy, and the difference between the two. So let's say there is a person who was doing good in his business and he soon wishes to expand his business. He goes to the bank and takes a loan of 1 crore rupees. Somehow, this person is not able to repay the loan. In essence, what he just did here is defaulting on the amount of the loan. So, the person who owes the debt or has taken the loan will be referred to as the corporate debtor, and the person who provided the loan will be referred to as the creditor. Friends, please understand that by person we mean a corporate person, and when we speak about creditors, there are two types of creditors. First is a financial creditor, and second is the operational creditor. Also, this limit for default under the code was previously 1 lakh, but after amendment it was raised to rupees 1 crore. We will discuss this in depth in our upcoming videos. So, by now, we might have identified three elements for insolvency. First one being the debt, second being a default, and third being a corporate person or a corporate debtor. Debt means a liability or an obligation. The second one is the default, which means the non payment of a debt. And the third, the corporate person, means all the companies that are incorporated under the Companies Act, under the Liability Partnership Act, or any other company that is incorporated under the law at the time being. But please remember, the FSP or the financial service providers are not included in this definition. Let us now understand the primal difference between bankruptcy and insolvency as per the code. So, under the code, bankruptcy is a term that is used for individuals and partnership firms. Also, note that only after the adjudicating authority or NCLT passes this bankruptcy order, the individual will be considered to be bankrupt. Also, any modification or recall in this order will be binding. One can find this under the section 126 of IBC code. So let's now understand where should you be finding the IBC code if you open the Constitution of India. So first of all, it falls under the concurrent list, that is list 3 in 7th schedule under entry 9. One can see the preamble of the code on the right hand side. Now friends, here is a question for you to comment down below, that why is this matter placed in list 3 and not in list 2? So, coming back to the preamble, friends, preamble forms the soul of the entire code, which means that anything in the code will be in line to the preamble. So, in true essence, it shows the spirit of the code. For our ease of understanding, here are three main objectives under the preamble. First, that it is an act to consolidate and amend all the previous laws relating to reorganization and insolvency and resolution. The second one being that IBC law applies to corporate persons, partnership firms, individuals, and now MSMEs through pre-packs. Third and most important, that everything in the code will be in a time bound manner. So, this ensures the maximization of value of assets, availability of credit, balance the interest of all the stakeholders, and establishing the regulatory body, that is the IBBI. Now, friends, let us understand the genesis of IBC. So, before the IBC came in, when the promoters were defaulting on the loans, there were many laws that were scattered and did not provide a one stop solution to this menace. Starting with the revival and rehabilitation under the Sikh Industrial Act, that is 1985, after which we had the Recovery of Debt Due to Bank and Financial Institution Act 1993. Finally, we came up with Sarfazi in 2002, post which the SICA got reappealed under the SICA Reappeal Act of 2003. The Companies Act 2013 too had some sections for winding up and striking off the company's name. While one law gave the power to drag these companies to court, the other act gave the power to liquidate the company. Clearly, these laws needed a more structured approach in a time bound manner, and this eventually led to consolidating all these laws under the code, that is the IBC code. So, more often, there are four pillars of IBC that provide teeth to the code. First is the regulator, that is IBBI. This is the Insolvency and Bankruptcy Board of India. Second is the adjudicating authority or the tribunal. A tribunal is a specialized court with a quasi judicial bench, which means that few members on the bench would be technical members and the majority would be judicial members. In our case, this is National Company Law Tribunal. The third pillar is the insolvency professionals. These are court appointed officers which look after the operation of the company once it goes into insolvency. It is their duty to keep it as a going concern. The fourth pillar is the information utility. These are data repositories that manage and store the data of creditors and debtors. At present, we have two information utilities. First is NESL and the other is the M junction. Friends, these are the important dates under the code. If one is appearing for LIE, this becomes extremely important. So you may pause the video and take a screenshot of this. Moving further, friends, we will discuss the broad five parts of which the IBC is divided, and in our upcoming videos, we will take them one by one. So the IBC code has been divided into five parts. The first part being the application and the definitions. The definitions contained under this part is applicable to the entire code. The part 2 contains corporate insolvency resolution process and liquidation for corporate persons, which were defined in the earlier part of the video. The third part consists of insolvency resolution and bankruptcy for individuals and partnership firms. The fourth part of the IBC code contains the regulations of insolvency professionals, the agencies, and the information utilities. So, this typically contains the IBBI incorporation, the preferential, undervalued, fraudulent, and extortionate transactions which are covered under this code. The fifth part consists of the miscellaneous part that includes things like cross border insolvency, the amendments, and the annual reports. So, friends, typically the corporate insolvency resolution process runs to a window of 180 days. An extension of 90 days can be taken, but when this benchmark is breached, the company is ultimately pushed into a liquidation process. So when this IBC came into picture, there were 12 acts that were amended under the IBC. This is a screenshot of the entire acts that have been amended under the act. So thank you so much for tuning into my video, and I hope that if you have any queries, you can comment them down below and do not forget to answer the question in the comments. Thank you.